I have a Reddit account and I received a direct question from a follower. What would you suggest for the following scenario? Before COVID, I was unhappy with one of my employees. I didn't officially fire her, rather told her we were making some changes due to COVID. She was fine with it and indicated she had taken a babysitting job that would have conflicted with her regular hours. All of this was in a phone call. I hired another employee for her hours. Do I need to document this any more than I have in this message? Thanks. As your business operations consultant, I would highly advise, yes, you would document this verbal termination. Based on what I've read, the employee in effect terminated her employment with this employer. Well, Nina, how do you document this verbally? Let's start with the following. I hope that when the employee was hired in your application process, you asked for and got that employee's personal email address. So what you're going to do, number one, you're going to send a confirmation email to that employee based on what was discussed in the phone call. You acknowledged the voicemail. Hi, employee X, I received your voicemail stating that you accepted another position and you won't be coming back to the company. I would verbatim list everything that was said in the conversation. Also, I would confirm that that employee accepted another job somewhere else, and due to the conflicting hours, she would not be returning to your company. I would also allow for some sort of rebuttal. I would end the email by stating, if this is wrong, if this is incorrect in any way, please send me an email to let me know. If you really want to be a stickler, you can also take that voicemail that the employee left, hit play, and record it on your computer. Your computer has a microphone and every computer comes with some type of recording program. You can record the voicemail, save it in a digital file under the employee's name. Finally, you can even go above and beyond and have a witness who can listen to the voicemail and yes, this person did in effect quit her job and sign off on it. Now, why do you want to go through all of this effort? You want to do that. They can't go and file unemployment stating that due to they lost their job. And this is a process that I would advise your business adapt in case of any type of verbal agreement between you and an employee. This can be used when an employee requests a temporary change in hours. It could be used when an employee is working from home and you want to confirm what job duties they would be doing at home. All kinds of scenarios. A bad employee is like a bad apple. Over time, that one bad apple will spoil the entire bunch of apples. Employees. Bad employees can be connected to lost productivity, low company morale, resentment, absenteeism and turnover, liability, profitability, and a whole list of other issues that have the potential to negatively impact your company. Managers, don't use employment policies and write-ups as a threat. If your company has exhausted every available means to assist that employee, and by this I mean counseling, training, motivation, and explaining to the employee how their behavior is negatively impacting the company, it's time to consider making the tough decision to terminate the employee. I recommend terminating an employee who is counterproductive to your company. With that being said, terminating an employee should be used as a final step and not one to be taken lightly. Think about how much it will cost your company to create and post an ad for the position, interviewing job applicants, background checking those applicants, orientation and training of the new employee. If that cost balances out with the negative issues overall lack of productivity, and corporate morale decline caused by the troubled employee, it's time to terminate. As you map out your termination strategy, be sure to include scenarios as to whom will perform the job duties of the terminated employee once they're removed from the company. No matter how much you need to terminate an employee, no matter how much better your company would be without that person, terminating an employee is still an unpleasant task. I've terminated over 30 employees between 2004 and 2016, and the only solace that I take is that the actual termination process for me is completed in a brief time. With proper planning, I am able to complete a termination in under 10 minutes, meaning from the time the employee sits down in the pre-designated area to the time he has been escorted off the property. That time takes me 10 minutes or less. Long ago, I created a termination checklist that I still use today. Of course, I've updated it over the years, but I'm going to share some of that with you right now. Is there an incident that happened within your company where the employee can argue that there was wrongdoing on your part? What can you do to limit your company's exposure prior to any termination? Prior to any termination, if you can think of anything where an employee could possibly bring litigation against you, please, I advise you to consult with an employment attorney, because it'll be cheaper for you to consult with the employment attorney before any type of litigation than after. Gather all your documents related to the reasons why you are going to terminate this employee. This includes written warnings, dates of verbal warnings, disciplinary documents, employee policies that were violated throughout the employee's tenure, counseling sessions, emails from management or other employees related to that reason why that employee is going to be terminated. Ensure that the employee, once they were hired, submitted all of your new hire documents. And I'm hoping that you do have things like non-competes and non-disclosure agreements and things like that. Plan who's going to perform the terminated employee's duties once they are gone. If you have a smooth transition between termination and the forward momentum of your company, it will make the employees who are remaining feel less threatened. Online access to accounts. And I'm not just talking about your company account. I'm talking about your client's accounts as well. On average, I've seen businesses have at least 20 to 25 online accounts. I personally, for my business, Nina Robb's Business Consulting, I have at least 35 accounts that are managed online: Office Depot, web domains, Microsoft, rent, social media accounts. If this employee that is about to be terminated manages all of those accounts, what you need to do, actually what you should always do regardless, is to have a list of the username, password, PIN number, and also, and this is most important, make sure that you, the business owner, is listed as the owner of that account. Either the business owner, one of the partner's owners, or your company name listed. This is incredibly important because, again, I speak based on experience, and if you do not own the account, no matter that your credit card is the one paying for the services on the account, you can't control the account, and that includes your client's accounts as well. Remote access. Nowadays, we all work remotely to some degree. This is one of the areas where you should start working on limiting that employee's access to your servers, your computers, your customers' accounts, your corporate accounts. Company property includes credit cards, office keys, laptops, cell phones, uniforms, anything that this employee uses on a daily basis that your company supplied. These are things you will want to make sure you have a list of. So when you have terminated this employee, you're sure that you're getting everything back. Notifying key customers and clients, and again, this is just my recommendation, is a big deal. And the reason why is that a lot of customers and a lot of clients do get attached to employees. And if you are the person who's telling them and explaining to them why this person was terminated, it would sound better coming from you versus once you have terminated this employee, they go to the client and they give their side of the story, and then you've got a client who probably will be upset, wondering why their favorite person is no longer with the company. Passcodes, depending on what your company has set up, alarm codes, online accounts, gate codes. Prepare your termination documents. I don't know how your business is set up, but if you were my client, there would be termination certificates and termination documents that employees would sign off on. In addition, if your employment attorney gave you a severance agreement and any other types of documents along those lines, those would be part of the termination documents as well. Let's talk about severance pay. Will you be paying a severance? TWC does not require you pay an employee any type of severance pay upon termination. So you have to decide if that's something you're going to do. If you are, you need to prepare that final paycheck. You have to calculate the final paycheck up through the day of termination. I recommend that employees are paid a final paycheck in a tangible check, not electronically. Well, why? Because I have heard, I've not experienced this, nor have I ever had a client that did this, but I did hear of a company that kept a terminated employee on their direct deposit. So this person, I think for 2 or 3 paychecks, still received a paycheck post-termination. The best way to deal with that is to take them off of direct deposit. Make sure they get a final pay check, paper. PTO. If your company pays out unused PTO, this is also another financial that you will need to resolve through termination. Cease payments and contributions to 401ks, flex accounts, and things like that. Let's talk about security. I did have an employee that I refused to let in the building. I terminated him away from the office because he did pose a security threat. Everything turned out fine with that. He did not come back in to destroy the office like he had threatened. So you have to make those types of determinations on your own. If you have someone who is a security threat, I would recommend you not terminate them inside your office. And if they are there, I would recommend calling police, letting them know of the situation, and requesting that they be on standby in case there is some type of issue. If your building has security, you would always notify the security and let them know that you terminated an employee and let them know why. And if possible, let them see a picture of that person. That way, if the person comes into the building post-termination, they can be stopped by security. Establish a termination date. When is this actually going to happen? I recommend that you do not terminate an employee on anniversaries, their birthdays, and holidays, personal holidays such as that. Where will you terminate? I recommend terminating an employee in a neutral place, not in a closed-in office where everyone is feeling trapped. Conference rooms typically work best for me. Insurance benefits. You would have to get with your insurance agent, and you can schedule when that person is no longer going to be with the company. I typically will call the insurance agent, and then I will say, I'm going to terminate blah, blah, blah person, and please terminate their insurance at the end of the month or whenever that payment cycle is about to end. And this is something that can be scheduled. And make sure you get that termination certification in writing from the insurance agent. And this includes health insurance, dental, any other types of insurances you have, life insurance, short-term, long-term disability. In Texas, we have to notify Texas new hire with the Attorney General, and you have to let the Attorney General know that the employee is no longer with the company. You just submit the termination date. Finally, wage garnishments. You must notify the entity that you are paying these wage garnishments to, that one, the person is no longer with the company effective blah, blah, blah date, and two, you must let them know we don't know where the person is going once they leave your employment. This is not an all-inclusive list of things that you would have on your termination checklist. This video was meant to get you started on your termination checklist. Each company has its own set of guidelines, its own set of rules. There are other things that I'm sure your company would have to do that would be different from this other person's company. This is a requested video, and I could have sworn I did this video a couple of years back, but I did not. This video assumes that you watched a prior video I did complete titled How to Terminate an Employee, and I'll put a link to it right here. For starters, I do not write termination letters. Many years ago, I created a 3-part termination system that has worked well for me throughout my management years, and I'm going to share it with you. Instead of a termination letter, I start out with something I called a termination notice. A termination notice explains to the employee the purpose of the document, and it discusses the reason why the employee was terminated. On a separate line, I clearly state you are being terminated for the following reason, and I list the reason there. And I make it as brief as possible. You're being terminated for unsatisfactory conduct. You're being terminated for violating an employment policy. You're being terminated for unauthorized use of company equipment. I keep it as short and sweet as possible. It also explains that unless the termination was the result of some sort of serious violation, that the employee had been warned prior to the termination. The second document I created is called a termination certification. This document is for the employee to certify that they do not have any more company property in their possession, that they've submitted everything that the company issued to them, keys, credit cards, computers, on and on and on. It also discusses any type of confidentiality, any type of non-compete or non-disparagement agreement that you signed. It reminds the employee that those are still in effect, even though the employee-employer relationship has terminated. Finally, I also create a termination statement. A termination statement is different for each employee. Please keep in mind that once you start the termination process, everything that you say could be used against you in a litigation situation if the employee decides to sue your company. So I create a termination statement so I can read what I'm going to say to the employee while the actual termination is taking place, and I can keep that information on file. Because I write down word for word what I'm going to say to the employee. Once I finish reading that statement, it's very short and sweet. I get up, the termination is done. I don't take questions from the employee. I don't add anything to the statement that I read. The employee receives a copy of the termination notice. The employee receives a copy of the termination certification, and I let the employee take that, they sign it, and they send it back to me. Well, Nina, what if they don't sign it and send it back to you? Well, there's a witness that should be on hand when you terminate an employee, either a manager or a high-level employee. And that person signs on the behalf of that employee. But honestly, I've never had a problem with a terminated employee signing and returning the documents. Termination statements, emails after the employee has been terminated, any communication post-termination should be kept on file in the employee's personnel folder. This termination system works for me, and it could be adapted to your company. If you'd like more information on my termination system, I'm going to put a link in the comment section below. If an employee asks to be laid off, be careful. Do not react like some employers have and fire the employee. Remember, if the employee resigns, they have the burden of proving good work-related cause to quit. It would probably be best to answer any layoff requests with a response to the effect that the request is denied and a reminder that the employee is still needed, thus placing the ball back in the employee's court. If the employee persists, follow that up with a statement to the effect that if the employee no longer wishes to work at your company, they need to submit a resignation request in writing and remind the employee that in the meantime, they still have a job to do. Whatever you do, do not prepare a resignation letter for the employee to sign. Have the employee prepare their own statement of resignation and then respond to that statement in writing, attaching a copy of the employee's resignation notice to the response. Be sure that any exit paperwork reflects that the employee resigned. Company is merely counseling an employee about a matter of concern, and the employee starts badgering you with questions and comments like, "Are you telling me I'm fired? So you're firing me for this?" Or, "I can't believe you're firing me for this. Watch out." Things like that are often seen in situations where the employee is trying to maneuver the employer into a premature discharge in the hopes that an unemployment claim might turn out favorably for them. The best response is something like this: "No, I am telling you that you need to start paying attention to instructions and follow the rules." Make it clear to the employee that your company is focused on improving their performance or on getting them to comply with policies. Once again, place the ball back in the employee's court, effectively letting them know without saying it out loud that if they want out of your company, they will have to take the initiative themselves. If an employee offers to resign, but you instead convince the employee to stay, and later you change your mind and accept the resignation, you have just discharged the employee. Persuading an employee to stay after they have tendered their resignation amounts to a rejection of the resignation, which means that the offer to resign has expired, and the employee's acceptance of your pleas to stay amounts to a rescission of the resignation. If a meeting with an employee starts out as a counseling session or a reprimand and the employee gets discouraged and watch out. If you immediately accept the resignation, it might be considered a discharge. It would be better to remind the employee that all you want to do is talk about the problem, not to let the employee go. Ask the employee whether resignation is really what they want. If the employee confirms that they want to resign, ask the employee how much notice are they giving. If they give 2 weeks notice or less and you accept the notice early within the 2 weeks, it will still be a quit, not a discharge. An employer does not have to pay an employee for the portion of a notice period that is not worked unless company policy promises such a payment. If an employee expresses a vague desire to look for other work, and the employer tells the employee to go ahead and consider this to be their final work day, that will usually not be considered a resignation, since no definite date had been given for the final day of work. A resignation under pressure is a form of discharge. If the employee had no effective choice but to leave when they did, it was an involuntary work separation, and the employer's chances in that case will depend upon its ability to prove misconduct. If you want to know more about business operations, business management, human resources, and other topics related to running a business, click on one of those play links. Click on one of these Click on the playlist.
One eternity later.
Click on one of these playlists. Thanks for watching. And don't forget to subscribe.